when we talk about the horrifying changes on college campuses, we should think not just about what's happening to Jewish students on campus, but also how it spreads, how it affects non-Jewish Americans, and how it's also spreading to K-12, to the workplace. After October 7, 2023, there was a newfound understanding that we were seeing something that could be characterized as a crisis, and that was seen, I would say, across the board among both Democrats and Republicans. The Biden administration became the first Democratic administration to use Title VI in the same way that it was being used for other groups other than Jewish Americans, which is to say it investigated a significant number of allegations. What about this apparatus under Title VI that is only finally now being used during the first Trump and Biden administration, and yet it is time-consuming, it is clunky, it requires enormous amounts of resources, and while the one remedy truly available to the federal government is termination of federal funds, that was never happened, never almost happened in all of those years. And so the question as we reached the beginning of the Trump administration was, when we have this extraordinary situation, this apparent crisis on campuses all over the country, are we going to use the same apparatus that had hardly ever been used, but which seemed to be slow-moving, cumbersome, and of questionable effectiveness? Or do we do something stronger?
Title VI focuses on ethnic discrimination, racial discrimination, discrimination on the basis of national origin. There is a history of argument over how Jews fit into that. I actually totally agree with Ken and others that Jews do fit into an ethnic discrimination pattern. Whatever is the true nature of Jews, whether we're truly an ethnic group or a religious group or some combination of both, for purpose of Title VI law, I think we do qualify as an ethnic or national origin group, and therefore anti-Semitic discrimination is similar to, say, discrimination against black people or Hispanics or some other ethnic or racial group. Here we face the question of whether anti-Zionism, for example, necessarily qualifies as anti-Semitism. Sometimes I think it clearly does, but there certainly are people who have objections to Zionism which are not based on anti-Semitism. What has happened under this administration is indeed in various ways unprecedented, and some of it really goes into areas which have little or nothing to do with combating anti-Semitism and is instead an attempt to assert federal power over higher education in various harmful, illegal, and dangerous ways. An obvious example is speech-based deportations of foreign students, and in some cases employees or faculty members, often even for speech that is not endorsing terrorism or is not anti-Semitic unless you define anti-Semitism super broadly. This violates the First Amendment, and it certainly has little or nothing to do with actually combating anti-Semitism.
A college's purpose isn't just to merely encourage speech. Obviously, it is one of the highest aims of higher education, but it is also to educate. And speech and education must transpire together in an area that is free of combat war zones, of encampments, of vandalism, of physical violence. These are natural exceptions to First Amendment conduct that should be easy for all of us to get behind. Time and again, we've seen that, yes, you may engage in conduct that could be considered anti-Semitic, but you don't have to be funded for it. And in fact, I believe the Trump administration has taken some of these edicts to heart. A funding condition can, of course, result in an unconstitutional burden on free speech, and the line is hardly clear, as we were just told, in an executive order, in a judicial ruling upholding the constitutionality of DEI executive orders on a First Amendment challenge. But specifically, we want to take a look at whether or not the activity that the government wants to subsidize seeks to leverage funding, and I believe the professor would agree that this is precisely what's happening now, leverage funding to regulate speech outside the contours of a specific program or activity. And then, of course, we saw agency guidance to all the federal executive agencies from Pam Bondi's office on July 25th, 2025, explicitly laying out where the protections existed in Title VI and in Title VII, among others, and laying out specific incidents of what might constitute anti-Semitism. So I think they are trying very, very hard to be very specific, but we understand that these are very murky constitutional waters. In the end, my number one solution, in addition to what the Honorable Paul Clement suggested at the lunch break, in addition to ideological viewpoint and diversity, would be to amend Title VI to include religion.
To paraphrase the opinion, the government cannot impose viewpoint-based conditions including a demand that the institution hire faculty to promote viewpoint diversity on a university's research funding, and it cannot bypass statutory procedures Congress wrote into Title VI. That should matter to everyone in this room who cares about the durable enforcement of our civil rights laws. If the government cuts corners, it should lose. And when the government loses on process and constitutional grounds, it not only loses credibility, it also fails to meaningfully protect Jewish students who have suffered actual unlawful discrimination on their campuses by incurring unnecessary delays. The demands levied by the Trump administration are constitutionally fraught and practically counterproductive. Let's start with the compelled definition of specific definitions of anti-Semitism. The government cannot force institutions, on pain of losing federal dollars, to enshrine a definition of anti-Semitism that sweeps in core, protected, political speech critical of Israel. Schools have an obligation to act. The fix for under-enforcement of Title VI is not to invent new powers or impose political conditions on institutions wholly unrelated to combating unlawful anti-Semitism. It's to use the process mandated by Congress and federal regulations and to use the definition of discriminatory harassment mandated by the Supreme Court of the United States. Anything else is legally suspect.